Philipp against Barclays Bank UK PLC.
Now, just as a matter of housekeeping, can I, as it were, fire a warning shot that because we have so many parties wanting to be heard and parties and interveners needing to be heard, I'm going to be strict about the timings. And before you begin, Mr. Goodall, can I also just mention that, in case it's, well, I hope it will be of assistance to you, that there are two matters that we are particularly keen to be addressed on. One is the matter that was raised yesterday, the juridical basis of the so-called Quince Care duty, and the second is comparative materials. And the only other matter that I mentioned just now is that the appellant's note on juridical basis refers us to the P.T. Satria case, which is really, I think, well, at the moment we're inclined to think is both helpful and important, but it's not in the bundle.
We have copies with us.
You have, right.
We can perhaps pass those.
Thank you. Yes, Mr. Goodall.
My Lords, this appeal concerns the scope of the so-called Quince Care duty propounded by Mr. Justice Steyn almost 35 years ago in Barclays Bank and Quince Care. The central question for determination is whether that duty is or can be of any application where a payment instruction is issued to the bank by the customer, him or herself, rather than by an agent to the customer. My client, Barclays Bank, supported by UK Finance, says that the duty cannot be engaged in that scenario, and the first instance judge, His Honour Judge Rushton QC, as he then was, agreed. The respondent, Mrs. Philipp, supported by the Consumers Association, says that the duty can or should apply even where the instruction is given by an individual customer. And the Court of Appeal agreed, holding that as a matter of law, the Quince Care duty does not depend on the fact that the bank is instructed by an agent of the customer. I propose to break my submissions into four parts. First, I'll provide an overview of the bank's duties when presented with a payment instruction by a customer whose account is in credit. Second, I will look at the Quince Care line of cases. Third, I will identify the errors made by the Court of Appeal. And fourth, I will address the central arguments relied on by the respondent in her written case. Turning then to the first topic, the bank's duties when presented with a payment instruction by a customer whose account is in credit. There are three duties that sit at the heart of this appeal. First, when the customer's account is in credit, the bank's primary duty is to execute promptly the customer's valid instructions. If it fails to do so, the bank will generally be in breach of mandate and liable for the customer's losses. Second, the bank owes a subordinate or ancillary duty to observe reasonable skill and care in and about executing the customer's instructions. The extent of the duty is to ensure that the customer's instructions are properly complied with. Has the bank properly ascertained and implemented the customer's instructions? As such, the service that the bank is providing is execution only, not advisory, and its duty is to ensure that the customer's instruction is properly executed.
There are a lot of words you've just used just now which aren't pointing in the same direction. A duty to insure suggests strict liability. That the bank must execute the instructions. It's not a question of taking reasonable care to, but you also talk about reasonable care in executing the instructions. It'd be helpful if we could be clearer about what exactly the bank's duty is.
Yes, well, I'm going to come on to look at each of the three duties in turn.
Right.
The second duty is to exercise reasonable skill and care in and about executing the duty. So to make sure that the bank actually understand what it is they're being asked to do and then complying with that instruction. And then the third duty, which is a facet of the second duty, is the quince care duty, which is a duty on the bank to refrain from executing an instruction where the bank has reasonable grounds for believing that the instruction, and I emphasise the word instruction, is an attempt to misappropriate the customer's funds. And the bank submits that the quince care duty can only arise in a situation where the instruction to the bank is given by a person who has been entrusted by the customer as an authorised signatory on the account. In other words, it's directed towards, and only directed towards, the bank taking care to comply only with instructions which have been properly given and authorised by the customer. And framed like that, as His Honour Judge Russon said at paragraph 163 of his judgment, the quince care duty exists in reasonable harmony with the bank's other duties. Now, the nature and ambit of these three duties is well established by authority, and the position as found by the Court of Appeal and advanced by the respondent on this appeal, we would respectfully say, drives a coach and horses through the well-established principles applicable to a banker-customer relationship and the carefully structured duties to which that relationship gives rise. So let me make these points good. Starting then with the first duty, the bank's primary duty is to execute promptly its customers' valid instructions. Now, I don't understand there to be any issue between the parties in relation to this. The classic description of the relationship between bank and customer is contained in Lord Atkinson's speech in Westminster Bank and Hilton, which we've set out in paragraph 11 of our written case, which is at core volume, page 57. Where Lord Atkinson says it's well established that the normal relation between a banker and his customer is that of debtor and creditor. But it's equally well established that the drawing and payment of the customer's cheques as against money of the customers in the banker's hands, the relation is that of principal and agent. The cheque is an order of the principal's addressed to the agent to pay out of the principal's money in the agent's hands the amount of the cheque to the payee thereof. So the position is, we say, very clear that when the account is in credit, the bank is obliged to comply with its principal's order, and any failure to do so will generally place the bank in breach of mandate and liable for the customer's losses. Now, there are 2 points in particular that should be noted at this stage. That the first is that it is important to be clear as to what is meant by the banker-customer relationship being one of principal and agent. It is not a fiduciary relationship. That is well established by high authority, including by the House of Lords in Foley and Hill, as long ago as 1848. That the bank is instead only acting as agent in the limited sense of being a paying agent. It is effecting payment for and on behalf of the customer at the customer's direction, pursuant to the bank's undertaking to repay the customer. Now, I highlight this point regarding a lack of fiduciary duty because, although there is rightly no pleaded case of fiduciary duty, I would suggest that at times in her written case, the respondent has lost sight of it because my learned friend slips into the language of the bank having to act in the best interests of the customer. Now, we don't need to turn them up. We can see that in particular at paragraphs 35(1), 45, 121 and 138 of her written case. The second point to note is that where the account is in credit, a bank can only refuse to honour a valid payment instruction in limited and extreme circumstances. In 1868, the House of Lords held in Gray and Johnson that the bank could not refuse to honour a payment instruction on grounds of mere suspicion or curiosity. That is now subject to the money laundering statutory qualification in the Proceeds of Crime Act 2002, such that the bank is required to refuse payment if it knows or suspects the payment facilitates the use of criminal property. But that is of no relevance here because the monies were not criminal property at the time of the transfers. The bank's primary obligation to comply promptly with the customer's valid instruction, which is also now enshrined in the Payment Services Regulations, is the bedrock of much else that follows, and indeed it circumscribes the ancillary duties that the bank is under. So that then brings me on to the second duty, the duty on the bank to observe reasonable skill and care in and about executing the customer's instruction. Now, the important point to note here, as I've already said, is that the service being provided by the bank in relation to a transfer is non-advisory. It's concerned with the proper execution of the instruction. And indeed, it's clear, we would say, from the terms in which the duty is framed, that the reasonable skill and care is directed towards the execution of the instruction. It's also clear from authority, including the decision of Mr. Justice Saville in Redmond and Allied Irish Banks, which is authorities tab 12, page 2448.
I'm sorry, can you give me a reference?
2448.
We don't have tabs, so
Fine. Thank you.
unless your colleagues have tabs, you can just give us the electronic.
Thank you.
Thank you.
Now, this was a case relied on by the bank before the Court of Appeal, but it was not addressed by Lord Justice Burse in his judgment. In this case, the customer, Mr. Redmond, had deposited a number of cheques in his account. The cheques were crossed as non-negotiable and for account payee only. Mr. Redmond was not the payee, but each cheque appeared to bear the general endorsement of the name payee on the back. The drawer of the cheques subsequently sued the defendant bank, alleging that it had wrongly converted the cheques. That claim was compromised by the bank, which resulted in the bank debiting Mr. Redmond's account with the face value of the cheques. Mr. Redmond then sued the bank, and we can see his argument at page 2451 at line 20, where Mr. Justice Saville says, what the plaintiff does allege is that the loss here sustained through the bank's debiting his account resulted from the failure of the bank to warn him that dealing with such cheques was risky, since the words not negotiable on them meant that Mr. Redmond could not have or give a better title to the cheques than the person from whom he had obtained them. And so he might be liable if any of the holders up the line had no good title of the cheques. The plaintiff asserted that if he had been given any such warning or advice, he would not have gone ahead with the transactions. And then Mr. Justice Saville addresses that argument from the final paragraph on that page, just below the number 40, through to line 25 on the next page. And perhaps I'll ask my lords to read that. There are 2 points worth highlighting from this passage. First, the way in which, by reference to earlier authority, Mr. Justice Saville described the duty as being to exercise a reasonable skill and care in interpreting, ascertaining, and acting in accordance with the customer's instructions. We see that at lines 42 to 43 on page 2451.
Can I just ask you if you can assist us? I understand, for example, if instructions were unclear, then the bank would have to interpret them. Does ascertaining mean something different from that?
Possibly, my lord. I mean, there's one case we'll look at in due course where the customer had given conflicting or potentially conflicting instructions in writing as compared to a subsequent telephone conversation. And the Court of Appeal in that case said that the bank hadn't actually properly ascertained the customer's instruction because the written instruction didn't tally with the subsequent oral conversation, or at least arguably it didn't.
And what sort of situation is covered by acting in accordance with the instructions? Because we know from what you've called a primary duty that it's not a duty of care, it's a duty to carry out the instructions.
Yes.
So what sort of situation is covered by a duty to take care in acting in accordance with?
Well, my lord, let's say, for example, the customer instructed the bank to transfer money to an overseas account, which required the bank to nominate or appoint a sub-agent for those purposes, a correspondent bank. Necessarily in that example, the bank would be obliged to exercise care in instructing that correspondent bank.
Yes, I see.
Those three aspects, we say, interpreting, ascertaining...
Sorry, I mean, on that, why wouldn't it then still not be an absolute obligation on the bank to effect the payment as the customer instructed? The bank taking whatever risk it has to take in sorting out its correspondent banking arrangements. Why is it just then a duty to take reasonable care?
I think it's more, my lord, that if the customer themselves haven't identified the particular means by which the payment should be effected, the bank needs to exercise care in constructing the means by which it does make that payment. I mean, there are certain cases, perhaps in Paget, I can show you.
Right, so I don't want to take up too much time on it.
But perhaps, my lord, it's worth going to Paget briefly just to show you the sorts of areas where this point arises. And that is at tab 36 for those using hard volume. At page 3289. And if my lords look at paragraph 22.54 at the foot of that page, over to the next page, you will see the sort of instances where this duty has been the subject of consideration by the courts. And it's all about the process, the means by which the payment's effected. And into 22.55 too.
Yes, thank you.
So my lords, going back to Mr. Justice Saville, those three aspects, we respectfully say, identify the focus and ambit of the duty. Has the bank properly ascertained the customer's instructions? Has it properly interpreted them? And has it properly acted in accordance with them?
We can't help observing that this whole section of Paget, the footnote references are very largely to Quinscare. The case called Royal Products and Midland Bank.
Yes, we'll come to that.
Is also referred to, but
we'll come to that.
You know, to make it clear perhaps that we're not necessarily taking for granted that the analysis in Quinscare is correct.
Yes.
That formulation of interpreting, ascertaining and acting comes from Stellingall, doesn't it?
Yes, we'll come to that in due course as well, but that's right, my lord. So that's the first point to highlight from this passage. The second point to highlight is Mr. Justice Saville's clear holding that the banker-customer relationship does not create any duty on the part of the bank to warn against or advise on the risks inherent in carrying through that which the customer wants to do. And as Mr. Justice Saville said, that sort of duty is, quotes, wholly different to the duty to exercise reasonable skill and care in and about executing the instruction. And that broader duty is not required to give efficacy to the banker-customer relationship. As I say, the duty to exercise reasonable skill and care in and about the execution of the instruction is concerned with the proper execution of the instruction. It does not give rise to any advisory duty on the part of the bank. Now, consistent with this, there are a number of cases which make clear that the bank does not owe any advisory duty to the customer, so as to require the bank, for example, to consider the commercial wisdom or otherwise of the particular transaction, the subject of the instruction. We've identified those at paragraph 15 of our written case, but it's not necessary to go to them at this stage, given the position adopted by the respondent in her written case. At paragraph 89 of the respondent's written case, my learned friend rightly accepts that the bank owes no duty to advise on the commercial wisdom of the transaction. But that concession, we respectfully say, is not carried through to its logical conclusion. If the duty is not advisory in nature, what content can remain beyond a duty to execute the customer's instructions accurately? Now, on this appeal, there is no issue that the bank properly executed Mrs. Phillips' instructions. The bank did exactly what Mrs. Phillip instructed it to do, transferring the correct amounts to the correct accounts in accordance with her instructions. Her complaint is not about the execution of the payments. So the duty of skill and care in and about executing an instruction cannot provide an argument for the respondent's arguments, or cannot provide a basis for the respondent's arguments on this appeal. It's untenable to suggest that the bank has breached it. Indeed, the respondent's argument is that the bank should not have complied with her instruction at all. which is something quite different to this duty of skill and care in executing the instruction. So I turn now to my second topic, the Quince Care line of cases. Starting first with Quince Care itself. The judgment is at page 2020, tab 1 for those using hard copies. Now, the facts were relatively straightforward. The chairman of Quince Care, a Mr. Harry Stiller, caused about £340,000 to be transferred out of the company's account, which he then misappropriated for his own purposes. Quince Care alleged that the bank, in executing the order to transfer the money, was put on inquiry that Mr. Stiller was acting for his own benefit and an unauthorised purpose. We can pick it up at page 2031. Beside the letter E, we see the heading, the alleged breach of duty by the bank towards Quince Care. Quince Care's propositions of law. On behalf of Quince Care, the following propositions of law were advanced. 1, there is an implied duty of care in the customer-banker relationship. 2, if the circumstances are such that they would raise questions in the mind of a reasonable banker as to whether the transaction was in fact truly authorised by the customer and for the customer's benefit, then the banker is under a duty of inquiry. 3, if no inquiry is made, then negligence is established. 4, the quantum of damages is the loss suffered as a result. And then Mr. Justice Steyn says that reliance was placed on Selingor and Karak rubber, which we'll come to in due course. And then on the following page, 2032, just above the letter E, reference is made to the first instance decision in Lipkin-Gorman, where it was said that Mr. Justice Elliott considered what a bank's relevant contractual duties are towards a customer, and he held the following propositions to be established. 1, the bank is entitled to treat the customer's mandate at its face value, save in extreme cases. 2, the bank is not obliged to question any transaction which is in accordance with the mandate, unless a reasonable banker would have grounds for believing that the authorised signatories are misusing their authority for the purpose of defrauding their principal or otherwise defeating his true intention. 3, it follows that if a bank does not have reasonable grounds for believing that there is fraud, it must pay. 4, mere suspicion or unease do not constitute reasonable grounds and are not enough to justify a bank in failing to act in accordance with the mandate. 5, a bank is not required to act as an amateur detective.
These were misassumption submissions, were they not?
They were, that's right, my lord.
Just accepted.
Yes, which was accepted. Mr. Justice Steyn then says, I found this approach instructive, but given the importance of the matter, it warrants an independent examination of the bank's duties. And then, if I could ask your lordships to read from that letter H on that page across to the letter H on the following page. would respectfully suggest that there are 4 things that are immediately apparent in relation to the quince care duty. First, the duty is directed towards, and only directed towards, a situation where there are concerns as to whether, in giving the instruction to the bank, the authorised signatory is misusing his authority for the purpose of misappropriating the customer's funds. In other words, the issue is whether an instruction, which on its face appears to be valid and in accordance with the mandate, has properly been given by the customer and accords with its true intentions.
Misusing is a slightly inappropriate word because actually it's a lack of authority.
Yes. Yes.
I mean, there was some doubt about the law, but I think it's pretty clear now that is the position.
That is the position, my Lord, yes.
Yes, there's no actual authority, and if the bank is put on knowledge, there's no apparent authority.
That's right, my Lord. Yes. Second, and relatedly, the duty is concerned with whether the order, and I stress the word the order, is an attempt to misappropriate the customer's funds. That is clear from the way in which the duty is expressed at letter G on page 2033, where Mr. Justice Staines says he has reasonable grounds for believing that the order is an attempt to misappropriate the funds of the company. And it's clear from the passage more generally. We can see it at letter D on the same page, 2033, where reference is made to the order having been dishonestly given. It's also clear from the letter E, where reference is made to, quotes, the legitimacy of the order. And the same point also emerges from the passage on 2034, the next page, between the letters E and F, where the judge talks about the order being part of a fraudulent scheme to defraud the company. So the focus is on the motives of the authorised signatory, not the payee. The third point is that Mr. Justice Steyn expressly acknowledged at page 2033 at the letter C that the duty to exercise reasonable skill and care in and about executing the customer's order is subordinate to the bank's conflicting duty to execute promptly the instruction.
Well, isn't he going wrong there in suggesting there's a conflict between the duty to exercise care in executing the instruction and the duty to execute the instruction?
Yes.
That there isn't a conflict of duties, is there, that needs to be somehow resolved or the two competing considerations balanced?
No, I accept that, my Lord. It all slots together very neatly in a classic quince care situation because, as my Lord says, one is looking to execute with skill and care the instruction. But it's important not to lose sight of the slotting together in the context of this appeal, because the quince care duty, if that's the right description, for which the respondent contends, has the effect of elevating the duty to one that trumps even the bank's primary payment obligation.
I mean, he's a bit equivocal because you pointed out where he refers to legitimacy and so on, but in that sentence he talks about the bank receiving a valid and proper order, and that makes it look as though there's the duty of care may require the bank not to obey a valid authorised instruction.
I think what he means by that, my Lord, is one that on its face is valid and in accordance with the mandate. It's an instruction that on its face is signed by a director or whoever it might be who's authorised under the mandate to give the instruction.
Well, one that there's no authority to give, and where there isn't apparent authority, it's hard to describe that as a valid order. A proper order.
Yes, I accept that, my Lord. I suspect what he is focusing on is one that on its face appears to be valid, as distinct from one that is legally valid.
What strikes me is that he adopts an unorthodox mode of reasoning in order to arrive at a conclusion which could have been arrived at on perfectly orthodox lines. Counsel's submission to him had been quite an orthodox one, particularly the second Roman case, 2031 E2F Roman 2, if the circumstances are such that they would raise questions in the mind of a reasonable banker as to whether the transaction was in fact truly authorized by the customer, then the banker is under a duty of inquiry. And then when one goes to what the judge says, he cites no authority for his proposition 2033A about implied terms of the contract between the bank and the customer. He then decides to, the route to an answer is to balance conflicting, countervailing, as he puts it, countervailing policy considerations. And then, having considered these countervailing considerations, he ends up between F and G at what he calls a sensible compromise, striking a fair balance between the competing considerations, is to say that a banker must refrain from executing an order if and so long as the banker is put on inquiry in the sense that he has reasonable grounds for believing that the order is an attempt to misappropriate the funds. So he's arriving at counsel's submission and a position which the board of the Privy Council arrived at in P.T. Satria on the basis of a body of authority as a perfectly orthodox principle of agency law.
I accept that entirely, my Lord. I'd make, I think, two observations, though. The first is, of course, that East Asia and the other lines of cases referred to in that were obviously dealing with a contract. One is here talking about an instruction, and one could conceivably say that perhaps there's not direct read across in that situation. The second point is that...
Well, it's given in the context of a contract.
Yes, I accept that. I don't want to overstate the difference, but it is at least a difference between the two situations.
I mean, the obligation to give effect to it is a contractual obligation.
Yes. Yes. The second point, my Lord, is, as is apparent from East Asia, that there is obviously, at the moment at least, under English law, no settled position as to what, in fact, the test is. The passage in East Asia, which we've identified in our note of yesterday, is itself obiter. And as it identifies, there is a different strand of authority emanating from Lord Neuberger's decision in Hong Kong in the Akaya case, which has been followed by the Court of Appeal in England.
Not from now on. The effect of P.T. Satcher, I would have thought, would be the Court of Appeal would no longer follow the...
It is Quinn and CC Automotive. Yes. So I entirely agree with my Lord. There's a perfectly rational way of characterising Quint's care within conventional agency principles. There certainly is no rational way of rationalising Quint's care as viewed by the Court of Appeal within agency.
No, well, that's the point I was going to come to. That if one treats Quint's care as the application of a conventional principle of the law of agency, then it clearly has no application to the present case.
No, that's right.
But if you take au pied de la lettre Mr. Justice Staines' formulation at 2033A, that it's an implied term of the contract that the bank will observe reasonable skill and care in and about executing customers' orders, then it becomes an arguable proposition that a duty is owed to the customer in respect of instructions emanating from the customer himself, because it's such a broad dictum.
Well, Lord, I would respectfully say that proposition is not arguable, because one needs to focus in that scenario on what is meant by the duty to exercise reasonable skill and care in and about executing the instruction. And I would respectfully say that cannot encapsulate a duty that the bank should not, in fact, execute the instruction at all, which is what the effect of the respondent's argument here is.
Yes, the only point I'm making really is that the way in which Mr. Justice Steyn expressed himself, if one adopts that, then it provides a terrain where it's possible for the argument against you to be advanced. Whereas if one if one rationalizes the case and his finishing position as being an application of law of agency in relation to ostensible authority, then evidently it's got no application in a case like the present where the customer deals with the bank directly.
Yes, I accept that, my lord, and I would certainly say that the punchline of Mr. Justice Steyn, if I can use that expression, is consistent, entirely consistent with conventional agency principles.
You would say the same as the point Lord Reid has made about the passage you took us to at E and F on 2034, because if you read that on its face, referring to reasonable grounds for thinking the order was part of a fraudulent scheme to defraud the company, that can translate directly into the sort of analysis the Court of Appeal made in this case.
Well, my lord, one is still focusing on the order. The focus there is, was the order itself part of a fraudulent scheme? The order here, the instruction here, was not part of a fraudulent scheme.
Well, I mean, the formula used in several cases is that the order was an attempt to misappropriate.
Yes.
And your point, presumably, is that, well, that the customer wasn't attempting to misappropriate anybody.
No.
But if you talk about it being part of a fraudulent scheme, it may well be that the fraudster was seeking to get the customer to do that which unfortunately she did. And in that sense, the words to which people have just referred at 2034F potentially are broader. You're saying that you have to construe it as being the intention of the person making the order.
That's right, my lord. The order has to be linked to the misappropriation, or the attempted misappropriation.
Yes, and the person giving the order has to be the person attempting the misappropriation.
Correct.
Yes.
I mean, I wonder whether even the extreme focus on misappropriation in the formulation at page 2033 at D is very slightly off beam going down this territory, because you might have other indications that someone who comes forward giving an instruction on behalf of someone else does not actually have authority on behalf of the other person.
Yes.
So obviously, if it appears that they're misappropriating that person's money, that's going to be a pretty good clue that they don't have authority. But in principle, you could have other indicators that they don't have authority, when presumably the duty would be not to comply with that instruction, even though on its face it looks like it's all right, but you know that it's not given with actual authority. So even to talk about misappropriation, even though that's a clear indicator in many cases, which will sort of trigger the duty to inquire further, but it's not just in that sort of case where you might have a duty to inquire further, but that also tends to suggest that perhaps the duty is concerned with blocking misappropriation. And indeed, Mr. Justice Steyn talks about, the law's got to be astute not to facilitate fraud and things that, and that feeds into his reasoning as well. Yes. It's a point, I think, that fits with what my other lords were putting to you about just the slight misfocus that one gets from Mr. Justice Steyn's formulations at various points.
Yes, I accept that, my lord. And certainly if one looks at 2034 between A and B, and the sort of considerations or factors that Mr. Justice Steyn identified as being relevant, and one can see there the sort of broader inquiry that perhaps my lord has in mind, including the bank's knowledge of the signatory, and the presence of unusual features. So I said that there were 3 points to draw out of Quintzko. The fourth is that it is only facts within the bank's actual knowledge, which may give rise to an obligation to make inquiries. That's clear from the passage at 2033 at the letter E, where Mr. Justice Steyn said that the critical question is what lesser stated knowledge than actual knowledge of the dishonesty suffices. So you're still focusing upon the bank's actual knowledge. Now, by definition, in a Quince-Care case properly so called, there are facts known to the bank which are not known to the customer, namely that the authorised signatory has issued a payment instruction to the bank. So there's an imbalance of knowledge. The bank knows more than the customer. In contrast, in an APP fraud context, there is no such imbalance of knowledge. The customer knows as much as the bank in relation to the payment instruction. Indeed,
is that always true? Might you not have a situation in which the bank does have some knowledge that the account to which it's being sent is might be connected with fraud, or might have received some information? Arguably, it did in this case at a certain point.
Well, that was, as it were, some time after the transfer. I mean, but
before the last transfer, maybe.
That was blocked. Yes.
Yes.
But possibly that's right. I mean, it might be that the police have notified the bank.
Exactly. So maybe it's not, you can cover that situation at some point.
Yeah. I mean, but certainly, in terms of the first two payments, let me put it that way, the customer knew as much as the bank in relation to the payment instruction, and indeed the customer's knowledge was superior because the bank was unlikely to know why the customer was making the payment, unlike the customer themselves. Now, but before we leave Quince-Care, I should just make one final point. If we go back to 2032 at J, Mr. Justice Steyn said there that as agent, the bank owed fiduciary duties to Quince-Care. Now, with respect, that is wrong, but it does not appear to have formed any material part in the judge's reasoning. Now, we saw reference in this judgment to the decision of Mr. Justice Elliott in Lipkin-Gorman. That case subsequently went to the Court of Appeal, and that's at page 2169, tab 7 for those in hard copy. And the court will, I'm sure, be very familiar with the facts of this case. Mr. Cass, sorry, page 2169.
2169.
Mr. Cass was a partner in the solicitor's firm Lipkin-Gorman. Lipkin-Gorman banked with Lloyds Bank, and the mandate provided that any one partner was an authorised signatory on the firm's account. Mr. Cass was a gambler, and he drew on the firm's account to fund his gambling. Lipkin-Gorman brought various claims, including against Lloyds Bank for dishonest assistance and breach of contract. Mr. Justice Elliott found that the bank was liable as constructive trustee, although that was subsequently overturned by the Court of Appeal. So again, this decision was concerned with a situation where the authorised signatory was acting in fraud of the customer. Lord Justice May gave the first judgment, but it's right to observe that in relation to at least this aspect of his judgment, he wasn't in the majority because Lord Justice Nichols agreed with Lord Justice Parker. We can pick it up at the bottom of page 2181 at the letter H, the final paragraph, where Lord Justice May says, I turn to the solicitor's claim against the bank based on contract or negligence. We are here concerned with the general relationship between a banker and his customer, in the common case where the latter has a current account with the former which is in credit. The underlying basis of this relationship is that it is one of debtor and creditor. The money deposited with the bank becomes its own. It is prima facie bound to meet its debt when called on to do so. And he then refers to Lord Atkinson's passage in Hilton, and he says, letter C, indeed any failure by a bank to honour its customers' instructions may well redound to the serious discredit of the customer himself. On the authorities, it's clear that at least in the last century, the terms of a customer's mandate to his banker in respect to his current account was sacrosanct. And he then refers to Bodnam and Hoskins and Gray and Johnston, which I mentioned earlier. And then over the page, at page 2183, we see by the letter D that he refers to Selingor and Karak rubber, which we'll come on to in due course. And if I can ask my lords then to read on the next page, 2184, from the letter E, just below the letter E, to the letter G on page 2185.
Yes.
Now, there are a few points worth highlighting in relation to this passage. Lord Justice May said that the principal obligation on the bank was to pay in accordance with its mandate on instructions, and that any implied term requiring the bank to exercise care must be limited. And he said that there's nothing which could require a banker to consider the commercial wisdom or otherwise of the payment. He then went on to stress that the circumstances where a banker is not required to honour the instruction must be exceptional. He then referred at 2185 between C and D to what had been said by Mr. Sumption, who acted for the bank. The bank should not treat its mandate as absolute, where, quotes, the relevant transaction was patently dishonest. We see that just alongside the letter D on 2185. Now, Lord Justice Burse appears to have considered that this assisted his reasoning when he said at paragraph 37 of his judgment that that concession was wide enough to cover the facts of the present appeal. But with respect to that is wrong. The transaction being referred to by Mr. Sumption was the payment transaction. And plainly the payment transactions in the present case were not dishonest. Mrs. Philipp was acting honestly and gave instructions to the bank, which she was perfectly entitled to give. Lord Justice Burse then went on, in paragraph 38, to set out what Lord Justice May had said at letters E to G on that same page. But it's important to view that passage in its proper context. What Lord Justice May was saying in the paragraph between E and G followed on directly from what he recorded Mr. Sumption as having accepted in the previous paragraph. If you look at the end of the previous paragraph, Lord Justice May says, counsel accepted that if a bank knows of facts which a reasonable bank manager would think were probably dishonest, then inquiry would be appropriate. The paragraph at E to F related to that issue. Hence, Lord Justice May said at the start of that paragraph that he was hesitant about laying down any detailed rules in this context. And the context was the last sentence of the previous paragraph. So the paragraph at E to G, but was not defining the ambit of the duty, because that was not necessary in the light of Mr. Sumption's concession. It was instead concerned with defining the standard of knowledge required by the bank to trigger the duty. The relevant part of Lord Justice Parker's judgment starts at page 2201. Where beside the letter B, we see the heading, the solicitor's claim against the bank. All the checks were within the bank's mandate, and there being funds to meet them, the bank's primary obligation was to honour them. Such obligation, however, is not absolute. It is common ground. Now, that is a reference back to Mr. Sumption's concession. It's common ground that in some circumstances a bank would, notwithstanding that it honoured a cheque duly signed by a person whose signature was authorised and required to honour, nevertheless be acting in breach of contract. An extreme example would be where the bank in fact knows a cheque is being drawn in fraud of the customer, or what amounts to the same, they turn a blind eye to the obvious. At 2205, we then see at the top the heading, the law, and in the paragraph that follows that, Lord Justice Parker expresses reservations about relying on expressions used in other cases, which he says turned on their own particular facts. And then on the following page, 2206, just above the letter D, we get the following. So far as breach of contract is concerned, the judge's approach was, in my judgment, more favourable to the bank than was justified, if, as appears to be the case, he considered that some want of probity was required, even to establish breach of contract. Mr. Sumption had not so submitted, nor did he so submit before us. If a reasonable banker would have had reasonable grounds for believing that Cass was operating the client account in fraud, and in my judgment, then in continuing to pay the cash cheques without inquiry, the bank would, in my view, be negligent and thus liable for breach of contract, albeit neither Mr. Fox nor anyone else appreciated that the facts did afford reasonable grounds and thus innocent of any sort of dishonesty. He then referred to Nihil and Nihil, which involved a claim against the bank for dishonestly assisting the trustee account signatories who had fraudulently used monies in the account for their own benefit. And then over the page at 2207, if I can ask you please to read between the letters A and D, so the first paragraph. Two points should be noted in relation to this passage. First, it's all concerned with an authorised signatory acting in fraud of the customer. And the focus here is on the degree of knowledge required by the bank in the light of Mr. Sumption's concession. This passage cannot provide, we respectfully say, any support for any broader duty of the type found by Lord Justice Burse. Second, when quoting from this passage in paragraph 34 of his judgment, Lord Justice Burse omitted the words between B and C from the or in this case to the end of that sentence. He admitted the words or in this case that there was a serious or real possibility that Cass was drawing on the client account and using the funds so obtained for his own and not the solicitor's or beneficiary's purposes. And instead, Lord Justice Burse sought to emphasise the preceding words that the customer quotes might be being defrauded. But it's clear that in that passage, Lord Justice Parker was talking about the customer being defrauded in the sense the subject of Mr. Sumption's concession. We can see that on the previous page at 2206 between the letters D and E, as I've already shown you, where Lord Justice Parker identified what in fact Mr. Sumption's concession amounted to. So he was talking about the customer being defrauded by the authorised signatory. Now, following Lipkin-Gorman, the quince care duty largely found itself gathering dust in some quiet corner of the common law, from which it only emerged over 25 years later. And we say that that itself is instructive because it serves to highlight its narrow application, a point that's stressed in some of the later cases. Its return to the fray took place in a case called Singularis. At first instance, the case was tried by Mrs. Justice Rose, and the judgment is at page 2595, tab 16, those in the hard copy. And she found that the bank was in breach of the quince care duty, and indeed this is the first and indeed only case to date in which that finding has been made.
I'm so sorry, I missed the page number.
Sorry, 2595.
Thank you.
Now, we don't need to trouble ourselves too much with the facts in this case, so if I could ask my lords simply to read the facts from the head note between the letters D and E on page 2595. And there are just a few paragraphs I want to highlight in this judgment. We can start at page 2639. Where we see just beneath the heading, just beneath the letter E, the heading, the claim in negligence. And then Mrs. Justice Rose considers both Lipkin-Gorman and quince care. We see that at 2639 across to 2641. At 2645, we then see paragraph 184 alongside the letter G. Where Mr. Justice Rose says, the issue for the court in this case is therefore whether in the context of a claim by the company against a bank for breach of the quince care duty, the director's fraud should be attributed to the company in order to defeat the claim. In my judgment, it would not be right to do so because such an attribution would denude the duty of any value in cases where it is most needed. The duty is only relevant, I'll stress those words, only relevant, in a situation where the instructions to pay out the money are given by the person who has been entrusted by the company as a signatory on the bank account. If there were no properly authorised instructions to transfer the money, the company would not need to rely on the Quince duty. The existence of the duty is therefore predicated, and again I'll stress that word, on the assumption that the person whose fraud is suspected is a trusted employee or officer. So the duty, when it arises, is a duty to save the company from the fraudulent conduct of that trusted person. Now, we don't need to turn it up, but that passage was expressly endorsed by Sir Geoffrey Ross in the Court of Appeal, dismissing the appeal, and that's at paragraph 56 of the Court of Appeal's judgment at page 2687. Sticking with Mrs. Justice Rose's judgment, if we go to page 2655, at the top we see her saying that the balance between the competing interests of the customer and the bank as the two victims of the deceit is struck here by the carefully calibrated threshold. Now, I think I'm right in saying that's the first time that expression of careful calibration is used in a judgment. Threshold of the Quince duty, taking into account the factors that were discussed by the judges in Litkin Gorman and Quince. It would not enhance the integrity of the law to undermine that balance by denying the claim on grounds of illegality in a case where ex hypothesi the exceptional circumstances needed for the duty to arise and be breached are found to be present. Now, Sir Geoffrey in the Court of Appeal also adopted the carefully calibrated language, and that's at paragraph 66 of his judgment on page 2689. And Sir Geoffrey went on in paragraph 86 at page 2694 to refer to the Quince duty as being, quote, narrow and well defined, and in paragraph 88 at 2695 to it having, quote, limited scope and arising in, quotes, very limited circumstances. Now, a subsequent appeal to the Supreme Court was dismissed. Lady Hale gave the only judgment, and that's at page 2699 at tab 18. Now, at page 2707, at paragraph 1, Lady Hale framed the issue before the court. And perhaps if I can ask my lords to read paragraph 1. Now, Lord Justice Burse appears to have attached some significance to this passage in his judgment, and he suggested that it provided support for there being an underlying principle that the duty was directed towards preventing funds being misappropriated. And that's in paragraph 27 of the Court of Appeal judgment. And he relied in particular for that on the words at D, that, quotes, the order was an attempt to misappropriate funds. But with respect to Lord Justice Burse, all that Lady Hale did in this passage was to refer to Mr. Justice Staines' decision in Quince and to summarise it. Lady Hale wasn't fashioning some new principle, and in any event, in line with Mr. Justice Staines' formulation, she used the language of the order being the attempt to misappropriate the funds.
Yes, so you're looking to the intention of the person who made the order.
Yes. Now, but one of the points before the Supreme Court was that if the fraud was attributed to the company, then the company's loss was caused by its own fault. And we can see that at paragraph 22 on page 2711, where Lady Hale says that Dewar argues that if the fraud is attributed to the company's loss is caused by its own fault and not by the fault of Dewar. In Reeves, Lord Hoffman referred to the sound intuition that there's a difference between protecting people against harm caused to them by third parties and protecting them against harm which they inflict upon themselves. People of full age and sound understanding must look after themselves and take responsibility for their actions. This was a case, argues Dewar, the company inflicted the harm upon itself. Now that, we would respectfully say, has some read across to the present situation. But if one then goes to the next page at paragraph 23, Lady Hale says that against that, Lord Hoffman went on to say that this philosophy expresses itself in the fact that a duty to protect a person of full understanding from causing harm to himself is very rare indeed. But once it's admitted that this is the rare case in which such a duty is owed, it seems to me self-contradictory to say that the breach could not have been a cause of the harm because the victim caused it to himself. And then Lady Hale says this is just such a case. The purpose of the quince care duty is to protect a bank's customer from the harm caused by people for whom the customer is one way or another responsible. And that, we respectfully say, reinforces that the duty is only concerned with what I might loosely describe as an internal fraud, namely a fraud by the authorised signatory on the customer. And that same point comes through in paragraph 35 on page 2715. Where Lady Hale says that the context of this case is the breach by the company's investment bank and broker of its quince care duty of care towards the company. The purpose of that duty is to protect the company against just the sort of misappropriation of its funds as took place here. By definition, I'll stress those words, by definition, this is done by a trusted agent of the company who is authorised to withdraw its money from the account. To attribute the fraud of that person to the company would be, as the judge put it, to denude the duty of any value in cases where it was most needed. If the appellant's argument were to be accepted in a case such as this, there would in reality be no quince care duty of care, or its breach would cease to have consequences. This would be a retrograde step.
That's an important paragraph because she's treating it as definitional.
Yes.
That it's an internal fraud.
Yes, that's right, my lord.
But to say that the purpose of the duty is to protect the company against fraud opens the door to the sort of argument that the Court of Appeal accepted.
Well, my lord,
It isn't really the purpose of the duty to ensure that the bank is acting only on a valid and authorised instruction from the customer.
that's right, my lord. But Lady Hale doesn't express the duty as it being to protect the company against fraud. She expresses it in 23 as to protect the customer from the harm caused by people for whom the customer is one way or another responsible.
But is that actually right? I mean, does the bank have a duty to protect the customer from fraud by people for whom it's responsible? I would see it rather that the bank's duty is to make sure that it is acting on the customer's instructions.
Yes, I accept that.
Not to protect the customer from fraud by anyone.
No, that's right, my lord. And I think the effect of the duty, or at least the effect of the bank seeking to make sure it's got proper instructions, has the consequence of protecting the customer against those for whom it's responsible. I entirely accept the way my lord has positioned the.
As I recollect, and Lord Sales will be able to correct me if my recollection is amiss, there wasn't any analysis of a quince care duty in this case. We were simply concerned with the issue of attribution.
I think that's right. I mean, the whole emphasis was on whether the instructions could be acted upon.
Yes. I mean, just certainly looking at the argument in the report, I mean, what one doesn't, there's no sense that the quince care duty was unpicked, as it were.
In fact, as I recollect, there was a conscious decision not to embark on analysis of quince care.
Now, I should also just briefly mention that between Singularis being decided by the Court of Appeal and the Supreme Court, the Court of Appeal gave judgment in a case called Nigeria and JP Morgan. It's not necessary to go to that case at this point, because the principal issue is whether JP Morgan's contractual terms ousted the quince care duty, with the court holding that they didn't. That case also concerned fraud on the part of the customer's agents. So it involved an entirely conventional application of the quince care duty. And at paragraph 7...
Even the language of talking about the quince care duty is apt to lead one into thinking that this is some special rule about banks.
Yes. I accept that.
So, I mean, I'm not suggesting you don't use it, but we need to be conscious of the fact that it is in itself
yes.
tendentious.
Yes, I accept that, and I'm using it simply as a shorthand, my lord. Paragraph 71 of the Court of Appeal's judgment in JP Morgan, Lady Justice Rose stressed again that the quince care duty was, quote, specifically aimed at protecting the customer from the fraud of its trusted employee or officer.
So sorry, remind us of the page number.
That was page 2306, paragraph 71. So at the time that the present matter came before the Court of Appeal, the cases spoke with one voice, namely that the quince care duty is limited to a situation where there is a concern that an internal fraud is occurring. In other words, a concern that the authorised signatory is acting in fraud of the customer. There were also two cases before the Court of Appeal in which an argument that the duty should extend to an external fraud had been rejected. The first is the decision of the Outer House of the Scottish Court of Session in a case called Seekers and Clydesdale Bank. We don't need to turn it up, but for your Lordship's note, it's at page 2471.
That was Lord Clark's judgment.
Lord Clark, yes, and he at paragraphs 18 and 21, in relation to an APP fraud in that case, expressly rejected the argument that the quince care duty could extend beyond an internal fraud situation. The second case is a case called Luk Wing Yan and CMB Wing Lung Bank, a decision of the Hong Kong Court of First Instance. And again, we don't need to turn it up. It's at page 2843.
And that was possibly given after the first instance decision here, wasn't it?
So like Seekers, it was given after the first instance decision in this case, but before it went to the Court of Appeal. And that case concerned authorised payments out of a personal bank account in circumstances where the customer was being defrauded by a bank employee. And as in the present case, all the transfers were personally authorised by the account holder, and there was no dispute that the bank was properly authorised to transfer the money. And the issue, as in this appeal, was whether there was any room for the quince care duty in those circumstances, and the judge, Mr. Justice Coleman, held that there wasn't. Now, the relevant part of the judgment is lengthy, and I would ask your Lordships in due course to read paragraphs 143 to 182, at pages 2924 to 2940. And you will see that the judge conducted a careful analysis of the authorities and concluded, drawing on the reasoning of His Honour Judge Russon in this case, that the quince care duty did not and should not extend to a situation where the payment instruction was given personally by the customer rather than through an agent. So that was the case law as it stood at the time of the Court of Appeal's judgment, which I respectfully submit clearly supports the conclusion that the quince care duty is only capable of arising where the payment instruction is issued by the customer's agent. It has no application where an individual personally issues the payment instruction on their own behalf. Now, two significant decisions have been handed down following the Court of Appeal's judgment, both of which I respectfully submit support the bank's position on this appeal. The first is the Privy Council's decision in JP SPC 4 against Royal Bank of Scotland, which is at page 2066. A case with which my Lord Hamblin, will be very familiar. In this case, the issue was whether the quince care duty extended to a duty owed by the bank to the beneficial owner of the monies held in the customer's account. And the court held that the duty did not extend beyond a duty owed by the bank to its customer. The judgment was given by Lord Hamblin and Lord Burrows, and I'd like to highlight just a few passages. The consideration of the quince care duty starts on page 2078 at paragraph 36. And we see in paragraph 36 that Lords Hamblin and Burrows refer to, or make reference to, Mr. Justice Steyn having, quote, carefully formulated and explained the bank's duty of care that was an issue on the counterclaim. Then at paragraph 38, the key passage I've already shown you from Mr. Justice Steyn's judgment was set out. And then in paragraph 39, on page 2080, 3 points regarding the quince care duty were highlighted by Lords Hamblin and Lord Burrows. And perhaps if I can ask my Lords to read paragraph 39, please. So subparagraph 3, the question of the passage in Mr. Justice Steyn's judgment concerning guarding against the facilitation of fraud was said to be needed to be read in context, and that same point comes through in paragraph 44 on page 2082, where the Court of Appeal's decision in this case was referenced. And again, the need to protect against fraud having to be read in its proper context.
Because that reflected the focus of the argument, because they're obviously relying on that
Yes.
passage.
Now, given the matters under consideration in this appeal, another important aspect of this judgment, we would respectfully say, is what the court had to say regarding the imposition of a duty of care based on an incremental development from existing case law. And consideration of that starts at paragraph 69 on page 2088. Where we can see the heading, duty of care based on incremental development, ground 7. But we can pick it up at paragraph 81 on page 2092, where it said, although it featured more in his oral than his written submissions, Mr. Giles Wheeler for the bank urged on the board that a further reason for caution before considering an incremental extension of the duty of care is that one is here concerned not merely with pure economic loss, but also with an omission, in the sense that what is alleged is the failure of the bank to step in to prevent harm being caused to the claimant by the wrong of a third party. Put another way, the duty of care would be one to protect the claimant against the fraud of the bank's customer. Now, the same is obviously true in the present case. We are here to concern with an alleged omission on the part of the bank in failing to step in to prevent harm being caused to the respondent by the wrong of a third-party fraudster. At paragraph 82, reference was made to the Supreme Court's examination of this area of the law in Michael and the Chief Constable of South Wales, and then also in 82, N and Poole Borough Council. And then we see at the end of paragraph 82, the last 5 lines, in both cases it was emphasised that the common law does not generally impose liability for failure to prevent harm caused by others. As Lord Toulson expressed it in Michael, it's one thing to require a person who embarks on action which may harm others to exercise care. It's another matter to hold a person liable in damages for failing to prevent harm caused by someone else. And then 83, in those cases, therefore, the Supreme Court recognised that for a duty of care to arise, restrictive principles needed to be satisfied. Those principles are most importantly and relevantly that the defendant has some special level of control over the source of danger or has assumed a responsibility to protect the claimant from the danger. And then 84, applying those principles to the relevant case, it can be seen that the bank had no special level of control over the source of the danger, i.e. it was not in control of the fraudsters. And for reasons already set out, it cannot be said to have assumed responsibility to protect the fund from the fraud. Therefore, viewing this case through the lens of the conduct of the defendant being an omission, in the sense of a failure to protect the fund from the fraud of the bank's customer, further supports the decision that the bank owed no duty of care to the fund. Now, precisely the same analysis applies here, that the bank had no special level of control. It was not in control of the fraudster, who wasn't even its customer. It did not assume any responsibility to protect Mrs. Philipp from an external fraud. And indeed, no assumption of responsibility is pleaded, and nothing crossed the line from which any assumption could be drawn. If we then go on to paragraph 95, on page 2095, we can see that the court endorsed what was said by the Isle of Man Court of Appeal about proposed duty having, quote, radical implications. We see that just below the letter B, and representing, just below the letter C, a massive extension with significant consequences for banking law. And it's respectfully submitted that the Court of Appeal's judgment in the present appeal extends the quince care duty to a much greater extent than that which was rejected by the Privy Council in JPSPC 4. And on any view, it represents a massive extension with radical implications. The second significant decision handed down since the Court of Appeal judgment is the Supreme Court's recent decision in Stanford International Bank and HSBC, which for your Lordship's note is at page 2717. And a number of my lords will be familiar with that case, having sat on that appeal. The principal issue in the Stanford case concerned whether Stanford International Bank had suffered any loss as a result of the assumed breach by HSBC of its quince care duty. I accept that there was no issue in that case about the scope of the quince care duty, but there are nonetheless 2 points worth highlighting. The first is that when describing the quince care duty, members of the court did so in entirely conventional terms, with the focus being on whether the instruction from the agent was legitimate. And in particular, I would highlight Lady Rose at paragraph 4, Lord Leggett at paragraph 37, and Lord Sales at paragraphs 88, 90, 133, 134, and 138. The second point worth highlighting is that Lord Sales stressed at paragraph 132 the importance of the quince care duty being kept within narrow bounds, lest it interfere unduly with the conduct of commerce, and that a bank should be able to act on a payment instruction promptly and without fear. And I would respectfully suggest that on no view is that the position that results from the Court of Appeal's judgment in this case.
Would you remind me of the paragraph of the last statement, Lord Sales' statement about keeping it in narrow?
Paragraph 132.
132, thank you.
I turn next to my third topic, the error made by the Court of Appeal and the fundamental problems arising from its decision. The central error made by the Court of Appeal was in extending the quince care duty by holding that its application is not limited to a situation where the bank is being instructed by an agent of the customer. I respectfully say that that is wrong in law and unprincipled. It lacks any proper juridical foundation, as we sought to identify in our short note, which we lodged yesterday evening. Lord Justice Burse recognised at paragraph 27 that all the previous cases in which the quince care duty had been considered had involved instructions from a fraudulent agent, but he was undaunted by that in holding that it could apply more generally. With respect to Lord Justice Burse, it is no coincidence that all of the previous cases concerned fraudulent agents. On the Court of Appeal's approach, even where a bank has an indisputably legitimate and valid instruction from its customer, the quince care duty can still override the bank's primary obligation to repay its debt, thereby placing the bank in an inherently conflicted position. The effect of Lord Justice Burse's judgment is to create a fundamental disconnect between the bank's primary obligation to make payment on the one hand and the quince care duty on the other. Now, this is highlighted most clearly by paragraph 27 of his judgment, which is at page 217. Where he says that in the second line, it's undeniable that the factual circumstances of the major cases in which what is now called the quince care duty has been considered have involved instructions from a fraudulent agent acting for a company or firm. And he then refers to various of the cases. However, what matters is the reasoning in these cases. That reasoning addressed below leads to the conclusion that despite the importance of the bank's duty to execute orders promptly, nevertheless, the bank does indeed have another duty, which operates in tension with that primary duty, such that the bank may be required to refrain from executing an order, if and for so long as the circumstances would put an ordinary prudent banker on inquiry. Now, what is immediately apparent about that passage is that Lord Justice Burse does not identify of what the bank must be on inquiry. If Quint's care is kept within its proper bounds, the nature of the inquiry is clear. Namely, is the instruction legitimate?
Or perhaps authorised.
Authorised, yes. If the Quint's care duty is untethered from the instruction, the nature of the inquiry is entirely at large. Of what is the bank trying to satisfy itself? It's not whether the instruction is valid or authorised, because there's no dispute that it is. The question becomes much more amorphous and involves matters that have nothing to do with the bank's mandate or its relationship with the customer. But moreover, in a conventional Quint's care scenario, there is a readily identifiable and manageable line of inquiry that the bank can usually perform with relative ease in satisfaction of its obligations. It can go to the customer and check that the authorised signatory is acting with authority. If, in contrast, the bank is under the sort of duty found by the Court of Appeal, the scope of the bank's obligations becomes much more uncertain. But when the bank is necessarily in the position of second-guessing its own customers' instructions, it's very difficult for the bank to know when it has gone far enough to satisfy itself that the customer's wish to make payment is not the product of fraud by a third party. That is fundamentally different from the normal Quint's care scenario, where the inquiry is simply binary.
Not only more uncertain, but more prolonged.
Yes. Yes. Further, if the Quint's care duty is kept within its proper bounds, as I said earlier, the tension between that duty and the primary duty to pay is largely removed, as His Honour Judge Russon explained at paragraph 163. If, in contrast, the Quint's care duty has the scope held by Lord Justice Burse, the tension can more fairly be described as a schism, because the bank becomes obliged not to execute a valid instruction, not because of any question or concern as to whether the instruction is in fact legitimate, but instead because of some open-textured question as to whether the payment the subject of the instruction will achieve the purpose that the customer really intends.
Again, you speak of legitimacy. I mean, it's a very broad word. I mean, Lord Reed says authorised.
Yes. Yes. Legitimacy is the word that was used by Mr. Justice Steyn. It's actually a word that's also used heavily by Lord Sales in the Stanford judgment. But I accept entirely it's a question of authority. Now, Lord Justice Burse's response to all this serves to highlight, with respect, the fundamental problem with his approach. And we can see that at paragraph 34 on page 219. Where we can see that he says the most convincing reason why a bank in the relevant example might not be liable would be if one accepted that the bank's service offered to the customer really was a, quote, execution-only service, and so in effect the respondent submitted on this appeal. However, that submission is wrong. And he then says the duty to exercise reasonable skill and care and the duty to execute are regularly described as being conflicting duties, although it may be more useful to say they operate in tension. And he then refers to Lipkin Gorman. And he says after that, how in a given case the tension between these two duties is resolved will depend on the particular facts. But that, with respect, is untenable, and it is anathema to an effective banking system, the operation of which is dependent upon certainty and precision, both from the perspective of the bank and the customer. And I would respectfully suggest that part of the problem in this regard is that Lord Justice Burse played down what was meant when it was said that the quince care duty was carefully calibrated. As I previously showed your lordships, that the careful calibration of the quince care duty was explained by Lord Hampden and Lord Burrows in JP SPC 4 at paragraph 39, subparagraph 2, as reflecting the fact that the duty is counteracting the receipt by the bank of what appears to be a valid and proper order, which is prima facie bound to execute. And the calibration is provided by the scope of the duty being limited and narrow. In contrast, Lord Justice Burse appears to approach matters on the basis that the careful calibration was provided not by the scope of the duty, but instead through the standard of care applicable to it. And that can be seen from paragraph 57 on page 224. Perhaps I'll ask my lords to read paragraph 57 and the emphasis that Lord Justice Burse places upon the last sentence of the citation from quince care.
I'm sorry to interrupt Mr. Goodall, but it just occurs to me to mention a point that it may be that Ms. Delaney might want to pick up. The suggestion in paragraph 34 that how the tension, as it's called, between these two duties is resolved will depend on the facts of individual cases. I mean, that's all very well. I mean, obviously you've criticised it, but one can at least understand the context if you're envisaging the situation in some of the older cases where you have the cashier who looks at the check and is familiar with the account and the customer who comes in every so often to meet the manager for a glass of sherry and so on. Nowadays, this presumably is all the subject of algorithms, so that fraud departments of banks aren't staffed by bank clerks who are. So there may be an issue about the practicality of what's envisaged in paragraph 34, which I'm not expecting you to address us on, but it may be that.
Yes, and in fact, one of the points that Ms. Delaney makes in her written submissions is that the practice across different banks or payment service providers are themselves very different, because obviously one is dealing here with a plethora of different sorts of payment service providers, and some providers might have more sophisticated systems than others. So paragraph 57 with the emphasis on the ordinary prudent banker, but paragraph 60, on page 225, he also then says the key is the careful calibration of the quince care duty itself. It is a duty conditioned by whatever ordinary banking practice is at the relevant time. Now, with respect, this approaches matters the wrong way round. Lord Justice Burse appears to have used the standard of care applicable to the quince care duty to justify the imposition of a broader and different duty without considering how that new duty fits with the calibration truly at play between the bank's primary payment obligation and any counteracting duty.
Yes, I mean, the practice of a professional or the practice of a bank may fix the standard of care, but it doesn't fix the scope of the duty. That's your point, yes.
In any event, not necessarily the case that there is any uniform, concrete, ordinary banking practice. That there may be a variation.
I mean, again, that follows from Mr. Delaney's written submissions, and as we said in our written case in one of the footnotes, one can always find an expert out there who'll tell you that a certain practice is standard after the event, and indeed, that's no doubt what would happen in this case should it go to trial. Now, Lord Justice Burse's conclusion as to why the quince care duty could apply equally to an APP fraud context can be seen at paragraph 30 on page 218. Where he says, crucially, the line of reasoning identified does not depend on whether the instruction is being given by an agent. it's capable of applying with equal force to a case in which the instruction to the bank is given by a customer themselves, who is the unwitting victim of an APP fraud, provided the circumstances are such that the bank is on inquiry that executing the order would result in the customer's funds being misappropriated. Now, there are two problems with that passage. The first is that it decouples the critical link identified by Mr. Justice Steyn between the instruction and the misappropriation. As Mr. Justice Steyn put it, the question is whether the bank has reasonable grounds for believing that the order is an attempt to misappropriate the funds. In other words, does the instruction itself form part of the attempted misappropriation? Instead, all that's required...
The order does form part of the fraudster's scheme, but it is not the instructor who is intending to misappropriate.
Correct.
Because what one sees in the Court of Appeal's judgment is repeated references in the authority to the relevant instruction being the attempt, and then at paragraph 71 are moved more towards the nature of the whole scheme itself,
yes,
where it speaks of the payment being sought. It was in fact an attempt.
Yes.
I mean, there's no doubt that the scheme of the fraudster was an attempt to misappropriate, yes, but the shift seems to be from the focus on the intention of the instructor to the nature of the scheme itself.
Yes. And indeed,
there's a related problem that Justice Burris is using the word misappropriation, which he's picked up from the earlier cases.
Yes.
There's no question of misappropriation in this case. You can't steal your own money.
No, that's when I say so. My second point. All that's required by Lord Justice Burris's formulation in paragraph 30 is that executing the order, quote, would result in the customer's funds being misappropriated. And so this decoupling of the misappropriation from the instruction leads to a very different reference point to that set by Mr. Justice Steyn. The second and related point is the point my Lord Reid has just identified, which is that the language of misappropriation is entirely inapposite in relation to a valid and proper payment instruction. That the monies paid out by the bank were paid out in accordance with Mrs. Phillips' expressed wishes. There was not a misappropriation in any conventional sense. It was instead a bank honouring its debt to its customer. Now, there are two further building blocks in Lord Justice Burris's reasoning, which is respectfully suggested led him into error. First, he started from the premise that the bank was not providing an execution-only service. We saw that at paragraph 34. And for the reasons I've already explained, that is wrong. Second, Lord Justice Burris appears to have based his reasoning on the notion that the payment instruction in an APP fraud context is, quote, vitiated by fraud. And we can see that at paragraph 75 at page 229. And we see that in the second line at the top of that page. If, as I believe is at least properly arguable, the law does require a banker to observe the objective standards of what an ordinary prudent banker would do if they were on inquiry, that an instruction may be vitiated by APP fraud. Now, this, with respect, is also wrong. One has to differentiate between two entirely separate things. First, the instruction received by the bank pursuant to its mandate. And second, the transaction between the customer and the fraudster. That the fraud in the underlying transaction between the customer and the fraudster does not invalidate the customer's instruction on the bank. The bank does not commit any fraud on the customer, so no right of rescission arises in relation to the mandate. And that is reflected in a passage from David Fox's book on property rights in money, which is at tab 148. page 6702. And I understand that at the time this was written, Mr. Fox was a fellow at St John's, Cambridge. He's now the chair of common law at Edinburgh.
I think he's a chair, is it banking law, banking and finance law at Edinburgh, I think.
So 6702, starting at paragraph 5.153, we have the heading, Avoidable Payments and the Effect on the Mandate with the Originator's Bank. The originator could not require the bank to recredit his or her account when he had made a voidable payment to the beneficiary. This would be true even if the beneficiary had induced the payment of fraud. The reason is the abstraction of the mandate between the originator and the bank from the transaction between the originator and the beneficiary. The fraud in the payment transaction would not invalidate the originator's mandate to the bank, nor even could the originator argue that his or her instruction conferred a voidable mandate on the bank, which the originator could then rescind. The bank would not have committed any fraud in the originator, so he or she could not exercise any right of rescission against it. So it's simply wrong to talk in terms of Mrs. Phillips' instructions having been vitiated. They were not vitiated by the fraud. So with respect to the framing of the duty by Lord Justice Burse in paragraph 75, tying it to the bank being on inquiry, that an instruction may be vitiated by AP fraud, it is legally defective because regardless of the fraud, the instruction remained valid and effective and one which the bank was legally obliged to meet. Now, in paragraph 68 and following of our written case, we set out a number of further fundamental problems.
I do apologise, you're right. Technically, his chair is the chair of common law. My dealings with him have related to banking and finance. But you're right, thank you.
So in paragraph 68 of our written case and following, we set out a number of further fundamental problems arising from the Court of Appeal's decision. And I don't propose to repeat those points now, but I want to pick up a few points that have been made in response to the Respondent's written case, which I haven't already addressed. The first point that we made in paragraph 69 of our written case is that the Court of Appeal's extension of the quince care duty cannot easily be reconciled with the legislative regime and the fact that the payment services regulations draw a distinction between unauthorised and authorised payments, payment service providers being liable only for unauthorised payments. I do not propose to say anything further on that topic at this stage, as I know that Ms. Delaney is planning to allocate her time to that topic. I want, however, to address the point made in paragraph 108 of the Respondent's written case, which is at page 142. Where they say at the top of that page 142, paragraph 108, that the most relevant legislative provision is the statutory implied term under section 13 of the 1982 Act. Now, the bank says that section 13 cannot assist the respondent. The first task under section 13 is to identify the service being provided. Here, the relevant service was the execution of the customer's instruction. So the implied term under section 13 is no broader than the common law duty to exercise reasonable skill and care in and about the execution of the instruction. We also made the point in our written case at paragraph 78 that the target of the new duty is of an entirely different character to that imposed by the conventional quince care duty. The target in a conventional situation is narrow and well defined, and is in respect of a matter that bears upon the bank's relationship with the customer, namely whether the purported instruction is legitimate. The target of the new duty found by the Court of Appeal is of a totally different quality. In essence, as His Honour Judge Russon said at paragraph 174, the duty for which the respondent contends amounts to the bank having to test the genuineness of the recipient of the monies rather than the genuineness of the instruction to pay the monies. And on any view, that is a radical change in the nature and scope of the bank's obligation. Now, the respondent's response to this only serves to highlight the remarkable breadth of her argument. If we turn to page 142, at paragraph 113, it said there that the target of the new duty is, quote, the protection of the customer. But it is not concerned with protecting the customer in the sense explained by Lady Hale in Singularis, namely protecting the customer from harm caused by its authorised signatories, but protecting the customer from acts of third parties and from the consequences of the customer's own decisions. At the heart of the duty contended for by the respondent is an issue of risk allocation. Who should bear the loss in relation to an APP fraud? And that is, with respect, a matter on which the courts are not best placed to provide an answer. That there are a multitude of different and competing considerations and careful balances at play here, along with broader public policy issues, which are matters best considered and addressed by the industry itself, or through legislation or regulation. And indeed, the industry stakeholders have been working to provide a solution, which has resulted in the CRM code, which itself is the subject of ongoing development and consultation, and legislation is now on the horizon. I want to turn now to my fourth topic and address some of the central arguments that are advanced by the respondent in her written case, insofar as I haven't already done so. My learned friend's central proposition is that the quince care duty is part of, quotes, a wider genus. And we can see that at paragraph 35, subparagraph 1 of his written case at page 119. Where he says, a wider genus concerning knowledge of threat to central purpose / intention requiring counteracting measures. And it's then said that there are a number of different authorities which show a duty requiring the bank to refrain from paying on a payment instruction where on notice of certain facts. And then we see in about the sixth line down, it said that the possibility of fraud on the customer is just one circumstance, but it said that the case law goes wider than that. And then 8 lines down in that paragraph, we can see that it said that the, quote, guiding principle which runs through the case law is that where the bank, as agent for the customer, is on notice of facts which show a real and serious risk that the/a central purpose / intention of the payment instruction for which they are providing a service may be invalidated. If they act on the instruction without delay or inquiry, any reasonable agent would consider that careless to the best interest of the customer and not reflecting their real / genuine desire. Now, I would respectfully suggest that it's not a very promising start for the respondent, that the duty for which he contends is expressed in such imprecise and unclear terms. If an obligation is to be imposed on a bank, it must be predictable as to when it arises and clear as to what it entails. The respondent's argument is developed further at paragraph 37 on the next page, page 120, where my learned friend relies under various headings on a number of authorities which are said to support this proposition, this wider genus proposition of law, but on analysis, none of the cases supports the proposition for which my learned friend contends. The first case relied on is at paragraph 37 under the heading mistake, and reference is then made to Westminster Bank and Hilton. And the respondent then goes on to say that the case is instructive because it was not concerned with whether the customer was being defrauded by its agent, but whether the customer had made a mistake. Now, I can deal with this quite briefly. For the purposes of this argument, the respondent places weight on the decision of the Court of Appeal in Westminster Bank and Hilton. But as my learned friend acknowledges, an appeal was subsequently allowed by the House of Lords, so one has to be cautious in placing too much weight on what was said by the Court of Appeal. But in any event, the decision of the Court of Appeal cannot assist the respondent. The case concerned an instruction by the customer to the bank to stop a cheque. However, the written instruction given, when viewed alongside a subsequent telephone conversation between the customer and the bank, was not clear. In particular, it was unclear which cheque the customer in fact wished to stop. And the Court of Appeal held the bank liable, but it's clear that it did so on the basis that the bank had breached the duty of skill and care in and about executing the customer instruction because the instruction was ambiguous and the bank had failed to clarify it before acting. So Westminster Bank and Hilton is an entirely conventional application of that duty because the bank had failed properly to ascertain the customer's instruction. And the case provides no support for any broader proposition that even where there's no doubt about the customer's instruction, the bank is somehow on inquiry in case the customer was mistaken in giving the instruction, as my learned friend suggests in paragraph 39 of his written case, or, as is suggested in paragraph 40, that the bank is somehow under an obligation to protect the customer from their own mistake, which we see at the end of paragraph 40. And there's nothing in the subsequent House of Lords decision to support such a broad proposition either. The next series of cases relied on by the respondent appear at paragraph 43 on page 122. And we see the subheading above paragraph 43, fraud on customer. And it's then said in paragraph 43 that the essential reasoning of Selingor, Carrack, Quintzcare and Lipkin Gorman is that the duty imposed by the bank is by reason of them being put, quotes, on notice of fraud on the customer. We see that at the end of paragraph 43. I've already addressed your lordships on Quintzcare and Lipkin Gorman, and as we've seen, they are both internal fraud cases. They do not provide support for any broader duty where the fraud does not concern the instruction given to the bank. The decisions in Selingor and Carrack Rubber were early manifestations of what became the quince care duty, and indeed you'll recall that Mr Justice Steyn referred to them in his judgment. Both cases concerned internal frauds, with the company's agent acting in fraud of the company. Selingore is at page 2488, which is tab 15. And this is a decision of Mr Justice Ungode Thomas. The facts were very involved, but in short, the case concerned a fraudulent scheme to misapply the company's property to finance the purchase of the company's stock. And various parties were sued, including Selingore's directors and its banks, District Bank and Bank of Nova Scotia. And the claims against the banks were put on the basis that they were constructive trustees and liable for negligence. If we then go to page 2540, I'm afraid it's a lengthy passage, but if I'd ask my laws to read from 2540, just above the letter G, through to 2542, just below the letter D. So about a page and 3/4, please. So this is all directed towards authorised signatories acting in fraud of the customer. At 2542C, as my Lord Hamlin observed earlier, Mr Justice Ungode Thomas uses the language which you saw adopted later by Mr Justice Saville in the Redmond case, of the duty of skill and care applying in relation to interpreting, ascertaining and acting in accordance with the customer's instructions. And he then goes on to say, and that must mean the really intended instructions of the customer rather than those of the dishonest signatory. Now, the respondent suggests that the last sentence of that paragraph, alongside the letter D on 2542, is particularly helpful to her case. But for my part, I don't understand that. The last sentence simply reinforces what has already been said, that although there is a presumption of correctness in relation to the instruction of the signatory, that is not so if reasonable skill and care indicate a different course. Now, you would have seen dotted throughout the respondent's written case references to Mrs. Phillips or the customer's, quotes, real intentions. And that expression emanates from this passage here at D, where Mr. Justice Ongo-Thomas talks about the signatures being misused to defeat the customer's, quotes, real intentions. But with respect to my learned friend, he relies on that expression entirely out of context, because what is being said here by Mr. Justice Ongo-Thomas is that what is relevant are the customer's intended instructions, not those of its signatories. And he was certainly not saying what the respondent is now saying, that even where there is and can be no issue that the instruction is genuine and valid, the bank is on notice if there is a possibility the underlying intention of the payment is, quotes, under real threat. If we go back to my learned friend's written case, page 123, we can see how he uses this concept of real intentions. At the top of page 123, reasonable skill and care requires it where a central purpose or underlying intention of the payment instruction is under real threat.
Well, to say that someone has no real intention is not a helpful way of expressing things, because it elides the situation where the person doesn't have any intention.
Yes.
And the case where they do have an intention, but they wouldn't have that intention if they were aware of certain facts.
Yeah. All Mr. Justice Ongo-Thomas was saying was that if the customer, if the company knew what the authorised signatory was up to, would they agree to it or not? Would they have the same intention? And then if one looks at paragraph 98 of my learned friend's written case on page 139, he says the point which both external and internal fraud cases share in common is that, subject to the necessary facts disclosing an unusual occurrence indicative of fraud, the bank knows that there are reasonable grounds for believing it does not reflect the customer's true, genuinely held intentions. I mean, that with respect is just simply not apposite language in circumstances where the customer has indisputably authorised the transaction, the payment transactions. You get a similar sort of formulation at the top of page 108.
The whole problem in these cases is that it is the customer's intention to transfer the money.
Exactly. One looks at the bottom of page 107. Subparagraph 2 of paragraph 4. A reasonable banker would appreciate what is contemplated does not reflect the customer's real intention / desire. Not quite sure what desire is adding in that scenario. And then again at paragraph 32, page 118. The third line. The payment instructions thus did not reflect her real intentions. So that's Selingor. That was followed by Mr. Justice Brightman in Karak Rubber, which is at page 2096, tab 5. This was also an internal fraud case where the company was subject to a fraud by those seeking to buy a controlling interest in the company by the use of the company's monies to fund that purchase. We can pick it up at the foot of page 2122. If I could ask my laws to read the final sentence of 2122 through to the letter H on the next page. So again, this is all directed towards the bank having grounds to believe that the authorised signatories are misusing their authority. So the reasoning in Selangor and Karak Rubber and in Quince Care and Lipton Gorman does not support the proposition advanced by the respondent that the duty being imposed was not limited to an internal fraud signatory, but was part of a much broader duty to combat fraud, even where external. And the problem is that submission is entirely untethered from the purpose of the Quince Care duty, which is for the bank to take care that it's acting on a legitimate instruction of its customer, rather than what may be a dishonest instruction of the authorised signatory. So there is not, to use my learned friend's language, some broader fraud genus of which the Quince Care duty is one part.
I mean, sorry, just to call attention before we leave page 2123 at the end, the judge there talks about misusing their authority for the purpose of defrauding their principal or otherwise defeating his true intention. So it's not just about misappropriation by the signatory.
No.
It's defeating or going outside what they've been authorised to do, and the bank knows it.
Yes, and I think that language actually is very similar to the language we saw in Selangor being used by Mr. Justice Ungo Thomas. And one is talking there about the true intentions of the customer as distinct from the intentions of the authorised signatory. And as my Lord Legate says, in a situation where the customer has personally authorised instruction, there can be no question about the customer's true intentions.
All this passage is perfectly consistent with an agency analysis, is it not? There is no actual authority, and given that the bank has notice of certain facts, there's no apparent authority, or there may not be.
Yes, it was nice and all. Now, the next case relied on by the respondent appears at paragraph 56 of the written case. which is the case that my Lord Reid referenced earlier. It's at page 126 of the core volume. You see the heading just above paragraph 56, funds lost to insolvency of Payer Bank, Royal Products and Midland Bank. In fact, that heading, I think, contains a typo. It shouldn't be Payer Bank, it should be Payee Bank.
Yeah.
Now, Royal Products is at page 2456, at tab 13. And the facts of this case were very involved and unusual, but they were summarised by Mr. Justice Webster at the start of his judgment. And if I could ask my Lords to read 2456, both the bottom left-hand column and the entirety of the right-hand column, please. So in short, the transfer in question was from one Royal Products account, that in the Midland in the UK, to another of its accounts held with Beacol in Malta, for which purpose Midland employed the use of a correspondent bank in Malta, namely National. Now, the transfer was effected via fairly complicated means, but Royal Products was not able to draw on the funds as a result of the liquidation of Beacol. And Mr. Justice Webster's judgment had to deal with various matters, including whether Royal Products' instructions were properly carried out, and if so, when. One of the allegations was that National, as Midland's agent, had breached their duty to exercise reasonable skill and care, and we can see that at page 2463 in the right-hand column, where there's a heading, was there a breach of duty in the carrying out of the instructions? And Mr. Justice Webster says the next issue to be considered is whether National were in breach of their duty to exercise reasonable skill and care in connection with the carrying out of the instructions. As I understand the pleadings, the only breach of that duty alleged by Royal Products is that National paid or remitted the amount to Beacol when they knew or suspected that Beacol were unable to pay their debts as they fell due, and that they were liable to stop trading. And then over the page, 2464, in the left-hand column, the first full paragraph, the judge says that for the purposes of my judgment, I propose at this stage to disregard the precise form of the pleadings and to assume it is alleged that National were in breach of their duty to exercise reasonable care and skill, either by paying or transferring the credit to Beacol when they knew or had reasonable cause to suspect that Beacol were unable to pay their debts as they fell due and were likely to stop trading. Now, Mr. Justice Webster then went on to consider the facts and concluded there had been no breach. For present purposes, it suffices to note 2 points. First, if we look at page 2458, in the left-hand column, at the foot of that page in the left-hand column, the judge stated that in carrying out the transaction, Midland owed Royal Products a duty to use reasonable care and skill, and he then cited Selangor and Karak Rubber. However, but beyond that, there was no consideration given in the judgment to the scope and nature of the duty, and there does not appear to have been any argument as to whether the duty did in fact extend to cover the pleaded allegations. And the judgment appears to have proceeded on the basis that it did, and we have not been able to locate any subsequent authority which has relied on or endorsed this aspect of the judgment. The second point is that it's important not to lose sight of a number of critical facts in this case. First, the solvency concerns are related to the receiving bank, not the payee itself. Second, National had actual knowledge of those solvency concerns. And third, having acquired that knowledge, National sought to persuade Royal Products to alter its instruction so that the payment was affected to Royal Products' account with National rather than the account with BCAL. We can see that on page 2466 in the top left-hand corner.
I think it was rather complicated because they couldn't mention the true reason.
Exactly.
So it looked as though they were just trying to get extra business.
When they sought to persuade Royal Products to change the instruction, National did not explain to Royal Products the reason why it was making that attempt. And that was because they didn't feel able to disclose the position in relation to BCAL, as they considered it was confidential information. So with respect to my learned friend, this case is a world away from the present case, and it doesn't provide any basis for the expanded quince care duty as found by the Court of Appeal. And we say this authority simply cannot bear the weight that my learned friend is seeking to place on it.
Seems putting it too high to say the bank owed a duty not to follow the instruction, but what would the bank owe a duty to warn if it had information? Suppose it had, well, it did have actual knowledge of the position of BCAL. Suppose that wasn't confidential. Would it have had a duty before carrying out the instruction to warn the customer of that fact?
I can see on the facts of this case, my lord, where it had actual knowledge and it sought to persuade the customer to change the instruction, that might have...
Well, it did in this. That's what it did. But what I'm asking is, did it essentially have a duty to do that, or not? Could it just have done?
I think, given what crossed the line between the bank and the customer in that case, it's difficult. It's easier to see how there could have been a duty to speak in that situation. If there'd been no contact at all, I would say no, there is no duty.
That is a dent into the non-advisory role of the bank.
Well, on the facts of this case, possibly, in the sense that there's a communication, or there's been dealings that are across the line, where the bank has had dealings with the customer in relation to the instruction. I can see in that situation how, what one could say, well, actually, there's some obligation in that situation for the bank to speak, because it sought to do something without being, at the same time, withholding information from the customer, information to its actual knowledge.
Well, I wonder if that's a convenient point. Very well. 2 o'clock.